Welcome to episode 5 of the Oregon Family Law Guy. I am your host, Hansery LaForest, and as always, we're giving Oregonians everywhere an insight to family law by teaching them the ins and outs of family law here in the great state of Oregon. It is Thursday, August 9th today. The weather for the past few days has been pretty hot. It's been pretty warm, which is kind of unfortunate. I was looking forward to it cooling down quite a bit, but it looks like over the weekend, I think that we're going to have a little bit cooler weather, going to dip down to the 80s. So I'm looking forward to that. I'm certainly looking forward to weather that's just a little bit cooler than what we've been having. Today we're talking about temporary custody, and specifically what we're talking about is what to do if you have an action such as a divorce or other dispute regarding custody, what you do in those situations before you have a final judgment, and specifically what happens to the children. Because that's a question that has come up a lot. I have seen a lot of people asking those sorts of questions, and there is an answer. And it involves 2 or 3 different kinds of orders that we're going to be talking about, and 2 or 3 different kinds of options for you in terms of what to do with the children before you get a settlement or before you have a final trial or hearing on the ultimate issue of custody. So the first thing that we're going to do is we're going to talk about when you specifically have a divorce, what sorts of automatic orders are put into place. The first and really the primary order that's put into place upon you filing a petition for divorce is something called a financial restraining order. Now, this is separate and apart from what an order that deals with children, which we'll get to in just a second. But a financial restraining order is basically an order of the court that basically prohibits any party to a divorce from doing anything that would reduce the value of an asset of either party that's subject to the divorce, which really is everything. And so what we're talking about here is we're talking about bank accounts, we're talking about real property, and by real property I'm talking about houses, land, things of that nature. We're also talking about personal assets, personal property, cars, jewelry. Okay, you can't go off and abscond with that property. You can't sell it off. You can't liquidate it, and you can't really do anything. You can't hide those assets. You can't do anything that would reduce the value of that property or eliminate that property altogether. Now, there are certain exceptions to this rule. For example, you can do at least a limited amount of stuff with the assets to pay off your attorney's fees, pay court costs, things of that nature. But that's a restraining order that's automatic with respect to the financial assets, specifically in a divorce. But that's not what we're talking about here. We're talking about, let's say that, you have children as part of a divorce, or let's say you're not even dealing with a divorce, but you're dealing with just a normal custody dispute. What happens with respect to custody and visitation before you can actually get your day in court? Well, there are certain orders that aren't automatic, but you can get from the court depending on if you meet certain criteria. And the way that I want to categorize this is there's a certain category of orders, or specifically an order that you can get if the kids are in danger, and there's a certain category of orders that you can get if they're not in danger. Let's deal with the first one. If the children are in danger, okay, you can get something called an emergency custody order. And that means that you go to court and you can do it in an ex parte fashion. The other party would be entitled to a hearing upon service of that order. But you get an emergency custody order in which the court issues or orders that one spouse or one party has custody of the children. And usually that order would also specify some sort of limited parenting time for the other spouse until they have some sort of dispositive or final hearing or judgment on the entire matter. So, for example, the court can order supervised visitation for the other spouse, subject to rules and conditions that may be requested by the other party. Again, that's something that's within the court's discretion. The court would have to have some sort of hearing on this. And depending on what the court finds, the ultimate issue being whether or not the child is in immediate danger, the court can issue that order. Now, when we talk about immediate danger, it means just that. You can't really get this order if there's not some sort of immediate physical threat to the child. So we're talking about situations where maybe one spouse has been indicated by CPS or DHS for some sort of child abuse. Maybe there's some sort of showing that that spouse, while the child was in their custody, that spouse or that party was under the influence of drugs or is in a relationship or has that child surrounded with someone who's a sex offender, okay? These are just examples, but that's an example of the sort of evidence that a court is going to want to look at in rendering, deciding whether or not to render an emergency custody order. So that standard is pretty high, and you're not really going to have that in a whole lot of cases. The emergency custody order is really for extraordinary cases of child abuse, child neglect, and when the child is in immediate danger. So in other cases, what do you do between the time that you file for your action and the time that you actually have your day in court to actually render that hearing? Well, there are two things, okay? One, there's a temporary custody order, and two, there's a status quo order. And I want to talk about both of those to get into what the differences are. A temporary custody order is exactly what it sounds like. It's a temporary order by the court where the court basically says, before we have a final trial or final order on who has custody and what's going to be the parenting time, we're going to temporarily render custody or have one spouse or one party have custody of the child, and we're also going to set some sort of parenting schedule. Now, here's the thing about this, okay, that you got to keep in mind. Number one, you require a whole hearing in order to get a temporary custody order. So what that means is that you can't really go in there and get that ex parte. You got to provide notice to the other party. The other party has the opportunity to object. Number two, you're oftentimes required to have mediation before you actually get that temporary custody order. So, and that's something that's required by the Oregon statute. So you're going to have to mediate that beforehand. Number three, depending on the jurisdiction that you're in, so for example, Multnomah County, you're not going to get a hearing for a while. Let's say that you file some sort of petition for divorce and you request a temporary order regarding custody and regarding parenting time. Well, typically you're not going to get a hearing or get before the court for at least a month, if not more than that. And it differs if you're in Clackamas or Washington. But the ultimate result of that is that it's going to take a while before you actually get that order. And most importantly, when you're dealing with a temporary custody order, the standard in a temporary custody order is going to be the same standard that you have at a final trial or a final hearing on the matter. The standard is what's in the best interest and for the welfare of the child. Okay, so that entire hearing is going to encompass everything that you would have at a final hearing or final trial on that issue. And that's going to be a topic for another podcast episode, but we get into, exactly, the nature of the parent-child relationship among either party. We get into who the child is bonded with. We get into the particular circumstances of the different parties. So this is going to be a full-fledged hearing if you're asking for a temporary custody order that is going to touch on a lot of things. The other type of order that you can get, and something that is oftentimes used in this particular situation if the parties can't reach some sort of agreement as to what's going to happen with the kids before or during the pendency of the action, the family court action, is something called a status quo order. Now, status quo is a Latin word for essentially the way things are at the present time. And so what a status quo order is where you keep the visitation and the arrangement that you currently have with the child as is. Now, it's commonly referred to as a status quo order. In the Oregon statutes, it's referred to a temporary protective order of restraint. Okay, and what it means is that the child's normal routine, his or her place of residence, schooling, etc., it stays in place until a further order of the court. Now, you can have a hearing on this. So let's say you go ahead, you get your ex parte status quo order, the other party objects. That other party is entitled to a hearing on that, but the hearing is going to be limited in scope. It's not going to be the same sort of hearing you would have at a temporary custody order hearing. Instead, the only issue that the court is going to try to decide is what is the status quo, what is the normal routine of the child at that current moment. And the court is going to take evidence or hear evidence and take testimony of both parties. They're going to listen to whatever evidence is provided by both parties, and if they make a determination as to what the normal routine of that child is, the court is going to issue an order ordering that that routine stays the same for the pendency of the case, at least until the parties have reached some sort of decision, some sort of settlement, or a final trial on the matter. So, what does all of that mean? Well, first of all, the other thing that you want to keep in mind before I forget is when you're dealing with status quo orders is you don't have to have mediation before you get that hearing. Okay, oftentimes, with respect to those orders, you can get it before mediation. Okay, so that's one thing to keep in mind. So what does all of that mean in the grand scheme of things? Well, if you're going through a divorce, all right, and you've filed for your petition, and there is an issue as to what's going to happen to the child or the children while you're waiting for things to shake out in court, either with your lawyers or you're doing it on your own. Well, the first course of action is to reach out to the other party and figure out if you can reach some sort of arrangement as to what's going to happen with the child, in terms of custody, in terms of visitation, things of that nature. If you can reach some sort of arrangement without court intervention, that's going to be one of the best things that you could do to serve your position. Now, I understand that's not always going to happen, okay? It's not all the time that you're going to be able to reach some sort of friendly disposition. So outside of if the child is in immediate danger, okay, and obviously if the child is in some sort of immediate danger, if they were to have visitation or custody with the other party, you need to be running into court as soon as possible and filing for an emergency custody order. Outside of that fact, you're really going to try to see if you can get a status quo order, okay? And what you can do is, you could do an ex parte, status quo order. Obviously, the other party would have an opportunity to object to that status quo order. And the basis of the objection is not necessarily, hey, I object to you filing the status quo order, but really it is if they say, hey, this is the normal pattern and routine of little Johnny or little Susie, and that other party says, no, it's not, then you can have a hearing. And the only thing that the court is going to decide in that limited hearing is what is the normal pattern and routine of the child. But you can go ahead and you can do that. Outside of that, let's say that you've got a normal routine, but for a variety of different reasons, you feel that that routine is not working and you need to get some sort of order or some sort of hearing before the court in order to change up that routine or change up that behavior, then you can go ahead and you can file for your temporary custody order. Keep in mind that, as we mentioned before, it's going to require a whole hearing. Okay, you're probably going to have to do mediation beforehand. You're probably not going to be able to get it pretty quickly, especially if your action here is in Multnomah County, and this is going to be a full-blown hearing. Oftentimes, what I see people do is, in lieu of doing a temporary custody order, they'll have that status quo order, okay, and maybe they'll try to reach an agreement, a written agreement about custody and visitation. And in that agreement, they'll specify that this temporary arrangement is not going to bear on the final order that ultimately gets issued in the case. And that's a way of avoiding having to go through that entire hearing, avoiding the court issuing an order that you don't like, and that could potentially negatively impact the ultimate order that the court reaches later on. Because keep in mind, as we mentioned, the order is going to be on the basis of the best interest and welfare of a child. And if they've already issued an order in a temporary custody order once as to what the best interest is, and it doesn't go your way, that could potentially have bearing in the final settlement. That could potentially give leverage to the other party to use that for a final settlement or a final hearing. So, it behooves, and the point of all of this is that it behooves, number one, both parties, outside of an emergency situation involving the children, to try to reach some sort of agreement. If they can't reach some sort of agreement, to try to get some sort of status quo order in place and negotiate for some sort of custody arrangement during the pendency of the case while things play out. And then if all else fails, then you can go ahead and try to file for a temporary custody order, keeping in mind that you're going to have to do mediation and that's going to require a whole hearing. So with all that said, that concludes our episode on temporary custody and what to do in those situations before final judgment when you need some sort of decision as to what to do with the children with respect to custody and parenting time. So, just a few little updates. This episode is going to be uploaded to the YouTube channel, and it's also going to be uploaded to Facebook. We are going to be trying to issue a couple more explainer videos. As we mentioned before in the episode beforehand, there is an explainer video out on YouTube, and it's also on iTunes. And it's going to be a series of different explainer videos. I just received some pretty good impact on the explainer video. I think that there's a little bit of a problem with the music. It was probably a little bit too loud for some folks to hear, the audio in the explainer video. So what we're going to try to do for next time is either turn that music down, or I'll try to look for some other music, something that's a little bit less cacophonous, a little bit more melodic, and a little bit more background, so you can hear everything that's being said. The third and final thing that I'm excited about is that I just bought a domain name for the Oregon Family Law Guy. It's going to be OregonFamilyLawGuy.com. Now, there's nothing there, so if you type in OregonFamilyLawGuy.com right now, you won't see anything. I just bought the domain name. But my plan is, over the course of the next couple days and weeks, to get a full website set up. Okay, and that website is going to be where these episodes are going to be hosted. So instead of going to YouTube, which we'll still post it on YouTube and still maintain the YouTube channel, you can just directly go to OregonFamilyLawGuy.com, get those episodes, subscribe, be able to comment directly on the website, and hopefully it'll provide a little bit more interaction with some folks. The idea here, as I said from the get-go, is to provide a shop for you folks, the good people of Oregon, some way to talk about some of these family law issues that you're experiencing. As I said before, and I'll say it again, this is not legal advice. I can't give you legal advice. No one can give you legal advice over this medium. Because it's just impossible. I mean, each and every single case involving family law is different. But these are helpful guideposts, and to the extent that I could help guide you in the right direction, I think that's my great vision for this podcast. I think that's my great vision for the Oregon Family Law Guy. So that's what's coming down the pipeline. So keep that in mind. as I mentioned before, we're going to put out some more explainer videos in the very near future.